Hello everyone, welcome back to my channel Statutes and Stories. Today we are delving into a crucial topic, the essentials of a valid contract according to the Indian Contract Act. Whether you are a business owner, a freelancer or just curious about legal matters, this video is for you. So let's jump right in. Contracts are the backbone of business and personal transactions, ensuring clarity, legality, and fairness in agreements. Understanding what makes a contract legally enforceable is crucial for anyone engaging in transactions in India. The Indian Contract Act was enacted in the year 1872 and it governs contracts in India. To understand essential elements required for formation of contract, first we need to know what is contract. In simple terms, a contract means when two parties put into writing an agreement which contains certain obligations which are to be performed by such parties, and when such written agreement becomes enforceable by law, it becomes a contract. Enforceable by law means when the agreement has acquired the force of law only for those who are a party to it, and a violation of those obligations would attract legal action including repudiation of the entire contract. Section 10 of Indian Contract Act lays down certain conditions which are required for a contract to be valid. It states all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So, the first essential requirement for a contract to be valid is offer and acceptance. Offer and acceptance form the basis of a contract. There can be no contract unless there is an offer, and such offer must be accepted. An offer once accepted becomes a promise. An offer is the first thing for the formation of a contract. A person making an offer is called an offerer or a proposer, and a person to whom the offer is being made is called offeree or proposee. An offer simply means willingness to do something or to not do something. It must be noted that if an offer is not made to get the acceptance of the other party, then it cannot be construed as an offer under Indian Contract Act. An offer must be made with the object of getting a favorable response from the intended acceptor. For offer to be valid, it must be communicated to the offeree. Mode of communication could be any but should be reasonable. An offer must be clear, specific, and capable of being understood. An offer should be lawful and not to do something illegal. Offer can be express or implied. An express offer is one which is made in words, whereas an implied offer is inferred from the conduct of the offerer. In implied offer, what matters is whether the offerer had any intention to make an offer or not. An offer can be revoked at any time before its acceptance by the intended acceptor, and an offer must be made with an intention to get acceptance thereto. As I stated earlier, the second step in the formation of a contract is the acceptance of the offer. Acceptance means when the person to whom the offer was made has given his assent to such offer. For acceptance to be valid, it should be absolute and unconditional and must be made while the offer is still subsisting. Acceptance to offer can be expressed or implied, that is, conducting in a manner which implies acceptance. Acceptance must be communicated in a reasonable manner, or if any, must be communicated through a reasonable medium like telephone, mail, WhatsApp messages, automatic reply to emails if there are no exceptions. Traditionally, acceptance was made through post or letters. If an acceptance is intended to be made through post, it will be deemed accepted when the letter of acceptance is posted and it is out of the reach of the acceptor. However, with the advent of instant communication like telephone, offer is accepted when the offerer hears the acceptance on his part. Acceptance or communication of acceptance by a third person or a stranger is not a valid acceptance. If a contract mentions a specific person to whom acceptance is to be communicated, then acceptance shall be deemed to be valid if it is made to that person only. Lastly, acceptance can be either in express words or can be implied, that is, by conducting in a reasonable manner which signifies acceptance. So, second condition required for a contract to be valid is consideration. Consideration means value given for the performance of a promise. It need not necessarily be money, however, it should be something which has been agreed by the parties and has some value. For a consideration to be valid, it has to be at the desire of the promiser, which means that it should originate from the promiser out of his own accord and not at the instance of a third party. Accordingly, the performance of a legal duty is thus not a consideration. Consideration could be past, present, and future. Past consideration is when promiser has received consideration before the date of performance of the contract by any party. Example, advance money paid. Present consideration is when consideration is provided immediately when the contract is made or executed. Thus, it is also called as executed consideration. Future consideration is when consideration is paid after making of the contract. In consideration given for construction contracts, constructed building is given after the execution of the contract. Consideration must not be illegal or void or impossible to perform. Consideration is not void just because it is inadequate provided it was at the desire of the promiser. It must be real, not illusionary. Consideration can be tangible or intangible. Example, performance of service like teaching or labor. Next condition required for a contract to be valid is free consent. According to Section 10 of Indian Contract Act, a contract is valid if it was entered into by a free consent of the parties. Section 14 of the Contract Act defines free consent as consent not given under coercion, undue influence, fraud, misrepresentation, and mistake. The general averment that consent was not free is not maintainable. It must be proved that consent was vitiated by any of the 5 elements mentioned in Section 14. If consent manifests any of such elements, then the contract is voidable at the option of the party whose consent was obtained. Section 15 of Indian Contract Act defines coercion as committing any act forbidden by the Indian Penal Code. An act would amount to coercion only when the act has been committed with intention to enter into an agreement. Mere threat of bringing a criminal charge does not amount to coercion, as it is not per se forbidden by Penal Code. But threat of bringing a false charge with the object of making another to do a thing is coercion because false charge is punishable under IPC. Section 16 of the Act states that if consent has been obtained by a person who is in dominant position compared to the other person, then it is undue influence. Dominant position includes situations where a person holds real authority or apparent authority, that is, authority which is not expressly stated but can be easily inferred by a reasonable man. The person who has the ability to dominate the will of other party has to prove that the contract was not entered into under the influence of a dominant position. When false statements are innocently made without the intention to deceive, then it amounts to misrepresentation. In misrepresentation, the person making the statement is innocent and has no intention to deceive the other party. The next requirement for a contract to be valid is intention to create legal relationship. Intention to create a legal relationship is one of the most fundamental aspects of law. It is defined as intention to enter a legally binding agreement or contract. It implies that the parties acknowledge and accept legal consequences in case of a breach of a contract. Intention to create legal relation consists of readiness of a party to accept the legal consequences of having entered into an agreement. It is essential to the creation of a contract that both parties should agree to the same thing in the same sense. Next requirement for a contract to be valid is capacity. As per Section 10 of the Indian Contract Act, an agreement is a contract if it is made among other essentials by free consent of the parties who are competent to contract. People who are of the age of majority and are of sane mind and are not disqualified are competent to contract. A contract entered into with or by a minor is void ab initio, that is, no obligation shall arise since its inception. A contract during the minority age of a party cannot be subsequently ratified after attaining the age of majority. This is because every contract needs a separate consideration. However, if a contract is made for the benefit of a minor, then it is a valid contract. Further, a minor can plead his minority as a defense in a suit, thus the rule of promissory estoppel is not applicable. Minor cannot be forced to fulfill the promise which he made when he was in minority, and estoppel, which usually prevents a promisor from going back on a promise, will not apply. This is because a minor, being incompetent to contract, is incapable of incurring any liability. According to Section 12, a person is said to be of a sound mind if at the time of making the contract he is capable of understanding it and is capable of forming a rational opinion about the effects thereof upon his interest. Disqualified to contract means a person not permitted to contract. Example: alien, enemy, convicts of a crime, an insolvent person. So next requirement for a contract to be valid is lawful object. According to Section 10, consideration and object of the contract should be lawful and is an essential element of a contract. Accordingly, Section 23 defines unlawful consideration. Unlawful consideration and object is one which is either forbidden by law or is of such a nature that if permitted, then it would defeat the provisions of law, or the purpose of the contract is fraudulent or involves or implies giving injury or damage to someone or to someone's property, or the court considers it as immoral or against public policy. If a contract shows any of these elements, then it is unlawful and void. Apart from conditions under Section 10, Contract Act specifically declares a few classes of contract as void. Section 26 to 30 deals with such contracts. These are those contracts which have been expressly declared void by the Contract Act. Section 26 expressly declares that an agreement which in effect prevents either party to marry, then it is void. Section 27 says that every agreement by which a person is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. It must be noted that the contract will be void only to such extent by which a person is restrained. Thus, the entire contract will not be declared void. According to Section 28, an agreement by which any party to the contract is completely or absolutely restricted in enforcing their right by usual legal proceedings in the ordinary tribunals, or which limits the time within which he may enforce his legal right, is void. Thus, if a clause in a contract prevents a party to initiate a suit against other party, then the agreement is void. An agreement which provides that a suit should be brought for a breach of any terms of contract within a time which is shorter than the period prescribed by Limitation Act is void to that extent. Section 28 further talks about those contractual terms which, although does not limit the period of limitation but extinguishes a person to claim a right or discharges any party from any liability if he does not do so within the time period mentioned in the contract. Such contracts are also void. Example, if a contract says that in case of breach, the party can ask for compensation only within 3 months from the date of the breach, and if such compensation is not asked within 3 months, then the breaching party will not be liable to compensate. In this case, the contract discharges the breaching party from liability. Further, according to Section 29, a contract is said to be certain if its terms are capable of being understood in the sense in which it has been intended to be understood by the promisor and are not ambiguous and vague. It should be capable of being reasonably interpreted by the courts. Certainty is achieved when intentions of the parties, safeguards, expectations, performances are clear or can be objectively ascertained. According to Section 30, wagering agreements are void and no suit shall be brought to recover anything that has been won by a wager. Further, no suit can be brought to make a person abide by the result of any game or any other uncertain event if such an act or event was subject of a bet. Understanding the essential elements of a valid contract is crucial for anyone entering into a contract in India. By ensuring that your agreements meet these criteria, you can protect your rights and interests. That's all for today's video. If you found this video helpful, please don't forget to like, share and subscribe for more legal insights. Until next time, take care.